Solicitor General's Office of Fulton County. Most of you have also had your initial appearance before a judicial officer, and bonds have already been set in your particular cases. Today, after conferring with an attorney, we are going to address each of your cases on a one-on-one basis to determine certain things. Number one, if you want to plead not guilty and have your case arraigned and scheduled for trial. Otherwise, perhaps your attorney and you have had discussions about a possible plea hearing in which you would make a decision as to whether you want to plead guilty or no contest in exchange for a recommended sentence. So in other matters, we may also address other issues raised by your attorneys, including the issue of bond. So during the course of these proceedings, please remember, as you can see, we are all addressing your cases via this virtual format. This is a recorded and live streamed proceeding. So please remember your rights. The first one is the right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. So please keep in mind to let your attorney speak for you. You have a right to an attorney. If you cannot afford one, or if you haven't hired a private attorney to represent you, we do have counsel from the Public Defenders and Conflict Defenders Office who would be able to represent you. All right, I see Conflict. Ms. McLeod is joining us. Good morning. All right, Deputy Francois, who do we have first in courtroom 2?
Yes, this is position 16, Mr. Goffin.
All right. Mr. Goffin, I understand that you are represented by counsel. After counsel has reached out to our office and is filing a waiver of arraignment. In other words, on your behalf, he's filing a plea of not guilty, and your case will be scheduled for trial. He will be contacting you shortly, and with respect to your case will be further notice for trial before the division judge. Do you understand, sir?
Yes.
All right, that concludes your case. Thank you.
And you're done. You can have a seat over there, Mr. Goffin. Next, we have position 1, Mr. Anderson.
Mr. Michael Jerome Anderson is case number 21 CR 005987F, accused of theft by receiving stolen property from March 20th, 2020. You've been advised of your right to remain silent, and your attorney is Mr. Derek Howard. Mr. Howard, you're representing the first half of the calendar?
That is correct, Judge. 1 through
All right.
16.
And what's a defense announcement?
Judge, this is a plea, and we're asking that to be entered as a nolo. I don't know if the state has an objection to that, but otherwise the terms we've agreed to.
Your Honor, we would object to the nolo plea on this position.
All right. Do you want to proceed as a non-negotiated on the status of the plea?
Yes, Judge, that'll be fine.
All right. Mr. Anderson, I'm first going to hear from the prosecutor with regards to the recommended sentence, and then I'm going to hear from your attorney. I will let you know which option I'm going to select before you make any decision to enter a plea. For purposes of this plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Ms. Sari, what's the state's recommendation in exchange for a guilty plea?
Yes, Your Honor, it's 12 months to serve 22 days, credit for time served 11 days, the balance probated, an anti-theft course, and no contact with the victim, Demond Schaefer's.
All right, and does he have any prior convictions for similar offenses?
Yes, Your Honor, there's a theft by shoplifting guilty conviction from June of 2005.
All right, anything else?
Nothing that's related to the charge, just the FTA probation violation and battered family violence.
All right, and if this case were to go to trial, what would the state have to prove?
Your Honor, the victim in this case, he had his phone stolen at the Atlanta airport. And on the date of the incident, the defendant was in possession of the phone, but he told officers he did not have it. And when the victim's phone was called, the phone number was called, the phone sounded in a towel located next to the defendant. So those would be our facts of this case.
All right, it's almost comical. Mr. Howard?
Judge, Mr. Anderson is interested in resolving this today. We do have some measure of dispute about the facts, but he acknowledges obviously that he was in possession of the phone. He wants to resolve this. We're asking that it be entered as a nolo, given he has not cleared anyone in the last 5 years. We'd ask the court to accept that.
I'll accept the nolo plea. Shall we proceed?
Yes, Judge.
Will the defense stipulate to venue and ID?
We do, Judge.
All right. Mr. Anderson, I'm in agreement to accept your no contest plea to this theft by receiving stolen property under the circumstances of the case. Since the phone was recovered by the victim and with little or no damage, I'll accept the no contest plea, but that doesn't mean that we will tolerate a repeat incident. Do you understand, sir?
Yes, ma'am.
All right. So, Mr. Anderson, first of all, are you under the influence of any kind of medication or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with the representation of your attorney?
Yes, ma'am.
If you decide to take this plea today, you would have to waive your constitutional rights to go back to court, to have a trial before a judge or a jury, to have your assistance of your counsel to challenge the state's evidence, to present your own defenses, to confront your accuser, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
And how do you plead to one count of theft by receiving stolen property?
When we talked about a nolo contendere, Mr. Anderson.
Mr. Anderson, how do you plead to one count of theft by receiving stolen property?
I guess plead nolo.
I accept your nolo contendere plea. Your sentence is 12 months to serve 22 days, credit for time served 11 days. If you have no other holds, you should be released within 24 hours. Once released, you must report to probation. Do we have a good address on this gentleman?
Yes, ma'am.
All right. Then probation will send you notice of when to report to them. Make sure you do report at the set date and time, otherwise a probation warrant will be issued for your arrest. While you're on probation, you will complete an anti-theft class, and you shall have no contact with, was it Damon Schaefer?
Yes, ma'am.
All right. And then, do you work at the airport?
No, ma'am.
All right. So unless you are employed at the airport or unless you have a ticket where you need to fly out within 24 hours, I'm going to require you to stay away from the Atlanta International Airport. Do you understand?
Yes, ma'am.
All right.
Judge, we would ask that if he's able to complete, once he completes the anti-theft course, that his probation be allowed to terminate.
I'm going to put it on a non-reporting basis.
Okay.
So I'm going to waive probation fees for the months of April and May. Once he completes his anti-theft class, his probation will be non-reporting. So he has 2 months to complete it. It's up to him.
Thank you.
Judge.
You're done, Mr. Anderson. Best of luck. Next case, please.
Position 18, Mr. Johnson, Jermaine Johnson.
All right. Is this Mr. McLean's case or
It-
Mr. McLean?
It is, Your Honor. Good
All
morning.
right. Good morning, sir. And what is the announcement for this case?
Negotiated plea on this, Your Honor.
All right, thank you. We are addressing Jermaine Bernard Johnson in case 19 CR 009-655F. Mr. Johnson was accused of giving false information and obstruction of an officer from May 23rd, 2019. Mr. Johnson, you've been advised of your right to remain silent. Your attorney is Mr. Mike McLean, and we are going to address a negotiated plea. For purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, thank you. Is it Mr. Segura? Good morning, sir.
Good morning.
And sir, we have Mr. Johnson before us. What is the state's recommendation for a sentence?
The state is recommending 12 months to serve 146 days, credit for time served 73 days, and a balance to be suspended.
And is this a concurrent sentence for both charges, or is the state going to null pros any of the charges?
The concurrent.
Concurrent, okay. Mr. McLean?
We ask that the court accept the plea.
All right. Mr. Johnson, excuse me, Mr. McLean, do you stipulate to the factual basis, venue, and ID, please?
We do so stipulate.
All right, thank you. Mr. Johnson, first of all, are you under the influence of any kind of medication or alcohol?
No.
And have you understood the proceedings so far?
Yes.
In speaking with your attorney, have you understood him, and are you satisfied with his representation?
Yes.
If you decide to take this plea, you would have to waive your constitutional rights to go back to court, to have a trial before a judge or a jury, to be able to confront your accuser, examine witnesses, present any defenses you may have, as well as have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes.
How do you plead to one count of obstruction of an officer and one count of giving false information to an officer?
Guilty.
Your sentence is time served. This concludes your case. Thank you.
Next, we have position 23, Mr. Reese.
That's DeShanta Reese.
Yes, it's
DeShanta, yeah, Reese.
That's correct.
Yeah, no.
and Mr. McLean, what are we doing for Mr. Reese today?
Negotiated plea, Your Honor.
Okay. Prosecutor Segura, with regards to this particular case, I'm trying to pull it up. There is a litany of charges. Are we going to null pros any of these charges?
And they're all going to be concurrent.
They're all going to be concurrent. Is that the agreement, Mr. McLean?
It is.
All right. This is case 15 CR 013773G. Mr. DeShanta Reese has 10 misdemeanor charges stemming from a traffic incident from a November 20th, 2015 incident. All right, Mr. Reese, hang tight. I'm going to read these charges, okay? They're required as a matter of law. You are accused of failure to change your address on your driver's license, failure to signal a lane change or turn, driving while license suspended or revoked, operating a vehicle while on an instructional permit or provisional license, giving false information to an officer, obstruction of an officer, failure to maintain lane, failure to maintain automobile insurance, failure to obey traffic control devices, and improper left turn. Did I get all the 10 charges in?
Sounds like it.
All right. And to these charges, Mr. Reese, understand that you're going to enter a negotiated plea. For purposes of the plea, you are represented by Mr. McLean, and you've been advised of your right to remain silent. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Mr. Segura, with regards to all these charges, is the state, well, it looks like it's 12 months to serve 15 days credit for time served and balance suspended.
Yes.
So it's essentially a time served.
Time
All right.
served.
And okay, that's fine. Mr. McLean, is that the sentence to which your client has agreed?
Yes, Your Honor. Time served, balance suspended on everything.
All right, and you stipulate to the factual basis, venue, and ID for all 10 offenses?
We do.
All right. Mr. Reese, are you under the influence of any kind of medication or alcoholic beverages?
No, ma'am.
And have you understood and are you satisfied with your attorney, Mr. McLean?
Yes, ma'am.
If you decide to take a plea of, I'm assuming this is a guilty plea to all these charges?
Yes, it is.
Yes, ma'am.
All right. If you are pleading guilty to all these traffic-related charges, you would have to give up your rights to have, to go back to court, to have a trial before a judge or a jury, to be able to confront your accuser, examine witnesses, to have the assistance of counsel to challenge the state's evidence and present your own defenses. You also have to give up your right to have the state try to prove all these charges beyond a reasonable doubt. Pleading guilty to some of these offenses as well will result in your driver's license being suspended. Are you prepared to go forward with this plea?
Yes, ma'am.
I can't hear you. You need to speak up.
Yes, ma'am.
How do you plead to all these 10 charges as I've listed them?
Guilty.
Accept your guilty plea. Your sentence is time served. If you have no other holds at the facility, you should be released within 24 hours. Thank you.
Oh, Your Honor, while we're on for a moment, may I ask, the state might recall that we needed some additional information such as an actual arrest report beyond the accusation on the add-on, Mr. Davis. And if that could be emailed to me, we could do something on that case today, perhaps.
All right. Who is responsible for Mr. Davis on the add-on calendar? Desmond Davis?
I am, Your Honor.
All right, Ms. Sari, if you have Mr. McLean's email, please email it to him. I appreciate it. Thank you.
I do not have his email.
Oh,
okay.
yeah, it's just mike.mcclain@fultoncountygA.gov. And
Okay.
McLean is spelled McClain.
Got it.
Thank you.
Thank you. Okay, next case, courtroom 2.
Position 3, Mr. Bolt.
Okay, we have Mr. Carson Bolt, accused of no driver's license and operating a vehicle on a wrong way in a one-way street and giving a false name from a April 24th. I'm assuming these numbers are not transposed, but this says 2002. All right, case number 03CR280291. Mr. Bolt, you've been advised of your right to remain silent. Your attorney is Mr. Howard. And Mr. Howard, is this going to be a plea?
No, Judge, I believe the state has an announcement on that one, Judge.
All right, Ms. Sari, yes?
Yes, Your Honor. The state is going to null cross this charge.
All right. Mr. Howard, does Mr. Bolt have other matters holding him?
He does, Judge. He'll have to be released to a hold.
Okay. Mr. Bolt, with regards to your traffic case from 2002, the state has indicated a notice of not to prosecute this matter. So this case is closed now.
Thank you, Your Honor. Thank you, Mr. Howard.
All right, you're
You're
free to
welcome.
go.
Thank you, Ms. Sari. Thank you, Mr. Walker.
Next, we have position 26, Mr. Seals.
Your Honor, the announcement on that is jail jury. The attorney of record I've spoken with to confirm that. He is in a trial courtroom and that proceeding is ongoing there.
All right. Who's the attorney?
Elizabeth Hogue, Hoague.
And as Ms. Hogue indicated, she's filing a waiver arraignment, or shall I proceed to arraign the case?
It was already on a trial calendar this week and I think must have been fully arraigned in the past. It was ready for trial, but there was a glitch on attendance.
Do you agree, whoever, Mr. Segura?
I do.
All right. Let me see if we don't have another. We don't have another trial date at the present time. With regards to this particular case, is this Bernard Seals?
It is.
All right. So Mr. Seals, in this particular case, 19 CR 007839E, you've been accused of reckless conduct and misdemeanor possession of marijuana from September 2019. All right. Please let Ms. Hogue know this, that apparently it was scheduled for a motions hearing before Judge Morrison, but presently is scheduled on a bond forfeiture calendar before Judge Morrison.
She's quite aware, right? We were all in attendance on the case.
Okay, it's on
Except for-
August 3rd, 2022.
We already
Okay.
said before.
All right.
Thank
Good.
you.
Everyone is, okay, so this is further notice for trial before Judge Morrison. Thank you.
Thanks.
You're done. Next, we have position 13, Mr. Fennec.
Mr. Michael Fennick is case number 22 CR 001-578J, accused of simple battery from October 5th, 2021. And he has been advised of his right to remain silent, and attorney is Mr. Derek Howard. Mr. Howard, announcement, please.
Judge, we're going to enter not guilty plea. It just needs to be arraigned. We do not need to address bond.
All right, and are we, do you waive a reading of the accusation?
We do. I presented him with a copy and read it to him, Judge. So,
All
yes.
right. Mr. Michael Fennick, in this particular case, you are accused of a misdemeanor offense of simple battery, as I've said, from October 5th, 2021, allegedly in Fulton County, Georgia. Based upon the accusation for a misdemeanor offense, if you enter a plea of not guilty, the case will be scheduled for trial. At the time of the trial, the state, the prosecutor, would have the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead? Please unmute. Mr. Fennick, given this information, how do you plead to the one count of simple battery?
Not guilty.
All right,
Not
sir. I accept your plea of not guilty. Your case will be further noticed for trial. That concludes your case. Thank you.
guilty.
Thank you, Judge.
Judge, I'd like to go back to position 16, Mr. Goffin, who would like to change his plea.
His attorney is not present at the today's proceeding. So his attorney would have to get in touch with him and schedule his case for a plea. I'm unable to take a plea today as his attorney is unavailable.
Understood. All right, Judge, we can go back to, Mr. Fennec is done. Position 4, 5, and 6, Mr. Braggs.
All right, thank you. All right, let me see if I got this right. Okay, Mr. Cameron Allen Braggs, is that correct?
Middle name is not Allen, but yeah, you almost got it.
Okay, I have Cameron Allen Braggs. I have Cameron Lee Braggs, and so Cameron Lee Braggs.
Yes.
All right, we'll go with Cameron Lee Braggs. Okay, and this is positions 5, 6, and 7.
Okay.
Mr. Braggs, you've been advised of your right to remain silent, and your attorney is Mr. Derek Howard. Mr. Howard, we have positions 5, 6, and 7 for Mr. Braggs, and what's your announcement for all 3 cases?
This is a negotiated plea. Just for housekeeping purposes, the actual sentence that's on position 5 that's listed as the sentence recommendation, we're asking that be, I guess, put on position number 7. I spoke with Mr. Walker about this in advance so that the jail won't have any confusion about how much time he served, because he's actually served the 26 days on that case, position 7. And if we put it on a different one, they may think that he needs to serve additional time. So other than that, Judge, it is a negotiated plea.
That is correct, Your Honor.
All right, Mr. Walker, you're going to have to articulate the recommendation so you keep me on track. But in the meantime, Mr. Braggs is got 3 separate cases. The first one on position 5 is 21 CR 006604H, accused of theft of services from May 8th, 2020. Position 6, case number 22 CR 000983F, accused of criminal trespass from February 22nd, 2022. Third case is criminal trespass for case number 22 CR 001204H from March 4th, 2022. I understand to all 3 cases, this is going to be a negotiated plea. So Mr. Braggs, for purposes of the plea, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes. Yes, Your Honor.
I'm sorry, could you speak up?
Yes, Your Honor.
Thank you. All right, Mr. Walker, what is the recommendation for Mr. Bragg's 3 cases?
So for position 5, we'll just enter time served. On position 6, time served, and then on position 7, it should reflect 12 months to serve, 45 days, credit for time served of 26 days, balance probated, an anti-theft course, 20 hours of community service, and then I have a stay away location of the Sugar Factory located here in Atlanta, Georgia, and Georgia Tech's campus. And I can give you the address to the Sugar Factory. One moment, Your Honor.
Okay.
It is 1080 Peachtree.
Thank you. And does he have any other holds besides these 3 cases?
Not to my knowledge, Your Honor.
All right. Mr. Howard, do you stipulate to the factual basis, venue, and ID for all 3 cases?
We do, Judge.
And this is going to be a guilty plea with respect to all charges?
That is correct, Your Honor.
All right. And also with regards to these 3 cases, do we have a good address to report to probation?
Judge, I do have an address that I can put in the chat. I've given him information. Our social worker is going to work with him in being able to get back to his home address where he desires to return to. But I can put that in the chat as well as his email address.
In that event, JCS probation, will Mr. Braggs have to report within 48 hours, no later than next Tuesday?
If he has a, good morning, Judge.
Good morning.
If he has a address, then he's okay, and I could just call him or email him his appointment. But he do need to know how to, what his stipulations is or whatever. So, but if you want him to report in 48 hours, that's fine too.
All right.
And just to clarify, the situation is he is desiring to return to his family in Cordova, Tennessee. That's the address that I have. We're going to have him connect with our social worker to get in touch with Travelers Aid to try to facilitate that. So right now in Georgia, he wouldn't have an address to give, but he would need to report probably by phone or email once he gets, back to his home address.
Probation, any objection to him reporting on Monday morning in person?
Not at all.
Okay.
He can come in.
That's
All
what we're going to do.
Okay.
And so, Mr. Braggs, and I don't know if the deputies have any more of the slips that we, with the address for JCS probation on it, but they will be so kind as to give him one of those with April the 4th or 5th? 4th is Monday?
Tomorrow is April 1st, so it will be April 4th.
Yes.
And it will be reporting to 132 Mitchell Street in Atlanta, Georgia.
Okay.
All right.
So,
All right, so let's proceed. With regards to Mr. Cameron Braggs, known as Cameron Allen Braggs and/or Cameron Lee Braggs, with regards to all 3 cases, Mr. Braggs, are you ready to proceed with the plea?
yes, I'm just trying to figure out how I'm gonna make it to these locations.
You need to speak up. I can't hear you.
I'm trying to figure out how y'all gonna get me to these locations to serve my probation and do my course, as well as the community service or the service charge I got.
And so we can talk further, Mr. Braggs, about the nuts and bolts of it, but you're going to have to report on Monday to probation. That's why we're going to give you the address so you'll be able to get there.
Mr. Howard, I'm so sorry.
Yes.
I didn't mean to interrupt, but Mr. Braggs has a case 22 SC 180868.
I don't believe that would be hold. Let me see. Is that holding him?
Right.
Yes.
Are you showing that's holding him, Judge?
I'm looking it up right now. It's just advised by our clerk's office. It appears so.
Let's see. Okay.
He's got a P&A before Judge Barwick on April 12th.
Okay. Well, Judge, it appears he may have a plea and arraignment, but I'm not showing that it's actually holding him in jail, right? He may have that plea and arraignment, and so I guess.
So
we
it
need
would
to
be
know that.
highly advisable not to go to Tennessee.
Right, until after, right, you've dealt with that. You have a court date on April 12th, Mr. Braggs, and I can talk to you more about, right, you're gonna need to come to the courthouse for that plea and arraignment date.
All right,
Once we're done, I can talk to you more about it.
okay, all right.
This looks like it was an indicted case, so I don't know if he's got a UJR. Yeah, you're gonna have to look into that, okay?
Okay, thank you, Judge.
It doesn't say. All right, Mr. Braggs, in that case, are you ready to proceed with your plea?
Yes,
All right. Mr. Braggs, have you consumed any kind of medication or alcohol recently?
no,
And have you understood the proceedings so far, including the issues with your probation?
yes, I think I do.
All right. And have you spoken to Mr. Howard about your case? Are you satisfied with this representation?
Yes, Your Honor.
All right. If also, is anyone forcing you or inducing you to take a plea today?
No, Your Honor.
And Mr. Braggs, if you decide to plead guilty to the charges in the 3 cases I have listed, you would have to give up your constitutional rights to go back to court, to have a trial before the judge or a jury, to have the assistance of counsel to be able to challenge the state's case, to present your defenses, examine witnesses, confront your accuser, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
And do you understand that taking a plea of guilty to these three cases could have an adverse impact upon any other open cases against you?
Yes, Your Honor.
And it also could have an impact upon any residency issues or an impact upon your occupation if they are relevant.
Yes, Your Honor.
With regards to case number 21 CR 006604H of theft of services from May 8th, 2020, how do you plead?
Guilty.
Your sentence is time served. This case is now concluded. With regards to case number 22 CR 000983F, the charge of criminal trespass from February 22nd, 2022, how do you plead?
Guilty, Your Honor.
Speak up, please.
Guilty.
I accept your plea of guilty. The sentence is time served. This case is concluded. With regards to your third case, 22 CR 001204H, accused of criminal trespass from March 4th, 2022, how do you plead?
Guilty, Your Honor.
With regards to this third case, your sentence is 12 months to serve 45 days, credit for time served, 26 days. If you have no other holds that are keeping you at the Fulton Jail facility, then you will be released within 24 hours to be placed on probation. Under the circumstances of your housing situation and the fact that you have an open court date in another case, you shall, this is not an option for you, you shall report to probation on Monday morning, April 4th, 2022, at 132 Mitchell Street in Atlanta, Georgia. You will be placed on probation to complete an anti-theft class, as well as to complete 20 hours of voluntary community service. I will waive your probation fees for the first 2 months that you are on probation. And if you completed your voluntary community service and your anti-theft class, then your probation will be non-reporting. You may return to Tennessee in order to complete the terms of your probation as long as and if you complete it within the first 2 months, then your probation will be non-reporting. At all times while you're on probation, active or non-reporting, you shall stay away from this location known as the Sugar Factory at 1080 Peachtree Street, and you shall stay away from all properties belonging to the Institute of Georgia Technology, or what we commonly refer to as Georgia Tech. Do you have any questions about your sentence, Mr. Braggs?
No, Your Honor.
All right, that concludes your cases. Thank you.
Thank you, Judge.
Your Honor, we have probation add-on 1, Mr. Juan Buenstro.
Add-on 1, okay.
Yes, Your Honor, that will be mine.
All right. Mr. Juan Buen Rostro, do we need an interpreter?
No, ma'am.
Okay. I'm just going to take a pause from this case. Miss Emily Gilbert.
Yes, ma'am.
All right. And what was your announcement? I'm so sorry. Could you tell us what you are retained counsel for what case? Or
This
for
one, Your
case?
Honor. Yes, ma'am. This.
Okay. So, Mr. McLean, are you representing Mr. Rostro or is it Miss Gilbert?
Only for a second last night, Your Honor. I'm glad to see counsel's in there.
Okay, so we're going to defer to Miss Gilbert then, correct?
Yes,
All
absolutely.
right. Okay. Mr. Juan Buen Rostro, this is a probation revocation matter for your case 15 CR 014742F. You have been advised of your right to remain silent, and your attorney is Miss Emily Gilbert.
Yes, sir. Yes, ma'am.
All right. We have probation officer, Miss Courtney Middleton, who is present on the Zoom. Miss Middleton, I'm going to place you under oath, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. I will first hear from Officer Middleton with respect to the reasons why they're seeking to revoke your probation. And then your attorney will address the matter, and then I will make a ruling unless I have any questions directly of you or your attorney. Ms. Middleton?
Thank you, Your Honor. The defendant appeared in Fulton County State Court on April 19, 2016 for the charges of battery and was sentenced to 12 months, was sentenced to pay probation fees, pay a fine totaling $680, report to probation, attend domestic violence intervention program, and submit to a drug and alcohol evaluation. He has 31 days left on probation, and probation recommends that his case be closed and he receives credit for time served.
All right. And do we know how many days he's served so far?
I do not know currently, Your Honor.
All right. Let me see. Oh, shoot. That doesn't tell me either.
Your Honor, I believe it may have been in the neighborhood of 7 to 8 days, maybe 9. I'm ballparking it, but
7 days right now. Okay. All right. All right. Ms. Gilbert, what is your response?
we would ask the court to accept that recommendation and close the matter.
All right. Mr. Buenrostro, I'm going to record this as a probation violation with regards to this case. However, based on the state's recommendation, I will give you credit for the 7 days you've been at the jail. And with respect to that, that is going to close out your case. And that's it. You're done with this case. Thank you.
Thank you.
Any questions, Ms. Gilbert?
No, ma'am. May I be excused, Judge?
Yes, thank you, Ms. Gilbert.
Thank you.
You take
Yes, Your
care.
Honor. Bye.
We go to add-on 2 probation.
All right, thank you.
Mr. Tate.
We have Mr. Demetrius Tate, accused of convicted of simple battery domestic violence in case 15 CR 006-986A. Mr. Tate, this is going to be a probation revocation matter. You've been advised of your right to remain silent, and your attorney is Mr. Mike McLean. Our probation officer is Ms. Middleton, and she will testify first as to the reasons why they're seeking a revocation, and then I will hear from your attorney. Ms. Middleton, you've already been sworn.
Thank you, Your Honor. The defendant appeared in Fulton County State Court on September 14, 2015 for the charges of simple battery, family violence, and was sentenced to 12 months of probation. He was sentenced to pay all fines and fees and to complete an anger management program. He has 1 month and 10 days left, where probation is going to recommend that he receives credit for time served and to close the case.
All right. Let's see if I can do this right now. Mr. Tate. All right, Mr. McLean, it appears that he's been in custody for 8 days and it will be credit for time served for 8 days, sentence commuted, and the case is closed. Anything else?
Nothing, Your Honor. He's in agreement with that.
All right, thank you. Mr. Tate, we're going to administratively close your case. However, this is going to be recorded as a probation violation. And you're given full credit for the time you've been at the jail, and that closes out your case.
Thank you, Your Honor.
All right, good luck, sir. Thank you.
You got position number 32, Mr. Woodard, position number 32.
Thank you.
That concludes my business, Your Honor. May I be excused?
Oh, yes, Ms. Middleton, thank you. If you'd like to email the documents to Ms. Grace.
Okay, I will definitely do. Thank you.
All right, thank you. We have State versus Abdullah Hosea Woodard, case number 22 CR 001586D. Mr. Woodard has been accused of simple battery from a March 18, 2022 incident. Mr. Woodard, you've been advised of your right to remain silent, and your attorney is Mr. Mike McLean. Sorry, thank you. And Mr. McLean, what's the announcement for this case?
That's a negotiated plea. I see from my paperwork, I always want to put an extra W in his name. It is Woodard and not Woodward.
Okay. All right. And Mr. Woodard, we are first going to hear from the prosecutor, and then I'll hear from your attorney. So for purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Thank you. All right, Mr. Segura. Yes, sir. What is the recommended sentence?
The state is recommending 12 months to serve 28 days, credit for time served 14 days, balance probated, 6 weeks anger management, 40 hours community service, a stay away from Malta, and no further contact with Jeff Pope.
And when we stay away from Malta, if I do a stay away, it's going to have to be at all locations, because I don't know how to keep him away from the main intersection, the main hub at 5 points.
Well, Your Honor, he may need to use MARTA in a way that doesn't take him to the hub. I've certainly done that for years.
Are you required to stay away from the hub, Mr. McLean?
No,
Okay.
I've been on routes in which I don't involve the hub in my movements.
Is that the state's position? Just stay away from the main 5 points intersection?
That's fine, Your Honor.
All right. Okay. Take a page out of Mr. McLean's travel benches. All right. Mr. Segura, anything else?
No, that's all.
All right. And Mr. McLean, do we stipulate to the factual basis, venue, and ID?
We do so stipulate.
All right. Mr. Woodard, have you consumed any kind of medication or alcohol recently? We need to unmute courtroom 2, please. Francois, could we unmute courtroom 2, please? Thank you. All right, Mr. Woodard, can you hear me, sir?
Yes, ma'am.
All right, sir. This, first of all, I have to ask you whether you've consumed any medication or alcoholic beverages recently.
I took my medication last night.
Okay. And are you able to understand what's going on so far?
Yes, ma'am.
Have you, when you took your medication, were you able to, well, before you took your medication and you had discussions with your attorney, were you able to understand him?
Yes, ma'am.
And are you satisfied with his representation?
Yes, ma'am. I'm here, ma'am. I never get out, try it all over again, do the right thing this time. Don't touch nobody. Don't have, I'm trying to get from it. I think lost. That's all I can do. I don't want to be about my phone.
I'm sorry, I couldn't understand a word you just said. If you can sit up and speak clearly, please.
I say, I gotta learn how to take a loss, stop touching people. When a loss come, how to take a loss, let it be just like that. Know how to take a loss. But
All right, from what I gather, you said you're taking a loss, so I don't understand that response. My question to you now is that you have to make a decision willingly and voluntarily whether you want to plead guilty to one count of simple battery that allegedly occurred on a Mata property involving one Jeff Pope on March 18. Listen very carefully. On March 18, 2022. Are you prepared to willingly and voluntarily and knowingly plead guilty to this charge?
Yes, ma'am.
All right. So understand that if you decide to enter this plea, you will have to give up your legal and constitutional rights to go back to court, to have a trial, to have assistance of an attorney, to challenge the state's evidence, to confront your accuser, examine and cross-examine witnesses, argue your case to a judge or a jury, and have the state try to prove the charge against you beyond a reasonable doubt. These are all rights that are afforded to you under our Constitution. But if you plead guilty, you have to give up these rights. Are you prepared to give up these rights?
Yes, ma'am, Your Honor.
How do you plead to one count of simple battery?
I plead guilty, Your Honor. I plead
Your
guilty.
sentence is 12 months to serve 28 days. Credit for time served, 14 days. If you have no other cases holding you at the Fulton County Jail, you will be released within 24 hours, but you must report to probation by next Tuesday at 132 Mitchell Street.
Okay, yes, sir.
While you're on probation, you need to complete a 6-week anger management program. You need to complete 40 hours of voluntary community service. You have to stay away from the entire Mata property known as 5 Points at 30 Alabama Street in Atlanta, Georgia. You know where that is, right?
Yes, sir.
You cannot be on its sidewalk. You cannot be in its parking lot. You cannot be in the station. You cannot use its bathrooms. Do you understand?
Yes, sir.
And you are to have no contact with Jeff Pope.
Yes, sir.
So if you do not report to probation by next Tuesday, which is April 5th, 2022 in the morning at 132 Mitchell Street, a probation warrant may be issued for your arrest. Do you understand?
Yes, sir.
And then you may end up serving the rest of the year in the jail.
Okay, Your Honor. Yes, sir.
And Your Honor,
Yes, Mr. McLean?
this is one where due to financial constraints, we would definitely ask the court to give him a substantial break on initial months of probation fees of $49 a month. He's going to try to get the class for free if he can. He might not be able to, but he thinks maybe he can get the class for free. So in doing the 40 hours of community service and the class, in addition to asking for the financial break on the $49 fee, would it be possible for him to go to non-reporting once he finishes those two tasks?
I will waive his probation fees, but he must report every month.
Okay, Your Honor.
Thank you, Your Honor.
And he must do the classes, and he must do the community service and stay away from modified points. If he violates any of these conditions, then, we welcome him back on the red carpet.
What's his
Understood?
date?
Thank you, Your Honor. Yes, sir.
Yes, Francois, what was that?
What's his date for the report for probation?
April 5th, next Tuesday.
Thank you.
Okay. All right, next case, please.
Position 25, Mr. Rosada.
That's one where I need a breakout room because it was TBA. He needed to think about something. And I told him I'd ask for a breakout room this morning to check on him.
Do we have any cases between positions 1 to 15?
Yes.
Okay, may I have that? And Mr. McLean, you can call the jail at 404-612-2392.
Got it. Thank you.
All right.
Dixon. Position 11, Mr. Dixon.
Thank you. Mr. Howard, what's the announcement on Mr. Dixon?
Mr. Dixon is going to be a negotiated plea, Your Honor.
Thank you. We have Mr. Ahmed Abdul Karim Dixon, case number 19 CR 0028478. Mr. Dixon was accused of criminal trespass on March 22nd, 2019. And this is going to be a negotiated plea. So Mr. Dixon, you've been advised of your right to remain silent, and your attorney is Mr. Derek Howard. For purposes of this plea, may I place you under oath? Raise your right hand, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah,
I was gonna say, let's ask for time
Yeah.
served, and if she can do it, then.
Yeah.
Mr. Dixon, could you speak up, please? I can't hear you.
yes,
Can you do that?
Thank you. All right. So, Mr. Walker, is it? Who's our ASG for Ms. Sari?
Yes,
You're
Your Honor.
dealing with Mr. Dixon, position 11. What's the recommendation?
Yes, Your Honor. The state and the defense have negotiated a plea to 12 months to serve 30 days, credit for time served 13 days, the balance suspended, and to stay away from the incident location. And I can grab that address for you.
And actually, Judge, Mr. Walker and I spoke a little bit this morning about this. We're asking that it be 26 days with credit for 13 days. He has actually served 13 days on 2 different bookings. And Mr. Walker agreed to, that it will be time served today. So we amend that to 26 days served, 13 days.
That's correct, Your Honor.
All right. Ms. Sari, if you don't mind, we will amend that to 12 months to serve 26 days, credit for time served 13 days, balance suspended, and to
Yes,
stay
Your Honor.
away from the incident location, and which is?
265 Peachtree Center Avenue,
Mhm.
and that's the Marriott Marquise.
Yeah,
Yeah,
not the big hotel with the 2 lions in front?
I believe so.
Okay, all right. No, I can't keep up with all these fancy places. All right. And Mr. Howard, do we stipulate to the factual basis, venue and ID?
We do, Judge.
All right. Okay, Mr. Dixon, have you consumed any kind of medication or alcoholic beverages recently?
no,
And have you understood the proceedings and the explanations provided by your attorney?
yeah,
I know, but still, that's.
Are you satisfied with this representation?
yeah,
If you decide to plead guilty to this charge today, you would have to give up your constitutional rights to go back to court, to have a trial before a judge or a jury, to confront your accuser, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
to give up the right,
Yep, if you want to plead guilty and accept the recommended sentence of time served, balance suspended, and to stay away from that big Marriott Marquis Hotel, you would have to give up your right to go back to court and have a trial.
yes, I plead guilty,
That's not an answer to my question. My question was, are you prepared to give up your constitutional rights to have a trial before a
Yes,
judge or a
yes.
jury?
yes, miss, yes, yeah,
Are you prepared to give up all the rights that I just listed, or would you like me to list them again?
I said yes, yes.
Yes to what?
I prefer to give up those rights. If I plead guilty, that means I took the plea, I will not go back to court. Yes, I said yes.
I'll accept your guilty plea. Your sentence is 12 months to serve 26 days. Credit for time served 13 days. It's essentially a time served plea. Balance suspended. You are noticed that you're to stay away from the entire location known as 265 Peachtree Center Avenue, which is the big Marriott Marquis Hotel. And if you are seen anywhere near its premises, on the parking lot, on the sidewalks, or heaven forbid, inside the property, you will be arrested and charged again with criminal trespass. Do you understand, sir?
Yeah,
All right, good luck. Thank you.
Thank you, Judge.
Next, we have position 10, Mr. Cosby.
Mr. Michael Cosby is case number 22 CR 001576F, charged with criminal trespass and public drunk on March 17, 2022. You've been advised of your right to remain silent, and your attorney is going to be Mr. Howard. Is this a negotiated plea as well?
Yes, Judge, this will be a negotiated plea, Mr. Cosby.
Mr. Cosby, since you plan to enter a plea in exchange for a recommended sentence, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Sari, what's the recommendation?
Yes, Your Honor, the recommendation is 12 months to serve 60 days, credit for time served 14 days, the balance suspended, and a stay away from all MARTA locations.
How many more days would he have to be at the Fulton County Jail?
It'd be about 16 more days, Judge, and he does have another matter holding him, so.
I see. Okay, thank you. All right, and does the defense stipulate to factual basis, venue, and ID?
We do, Judge.
All right. Mr. Cosby, are you under the influence of any kind of medication or alcoholic beverages?
No.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with the representation of Mr. Howard?
Yes, ma'am.
And I do understand that you do have other matters holding you at the jail. Are you still prepared to move forward with this plea willingly, voluntarily, and knowingly?
Yes, ma'am.
In doing so, you would have to give up your constitutional rights to go back to court, to have a trial before a judge or a jury, to be able to have the assistance of counsel to challenge the state's evidence, present your own defenses, confront your accuser, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass and public drunk?
No, Lou.
We'll discuss the guilty plea, Mr. Cosby.
Okay, well.
Again, how do you plead to one count of criminal trespass and public drunk?
Guilty.
I'll accept your plea of guilt to this case, to these charges. Your sentence is 12 months to serve 60 days. Credit for time served, 14 days. Once you have completed an additional 16 days, the remainder of the sentence will be suspended, and that will conclude your case. Do you understand, sir?
Yes, ma'am.
If you return to MARTA, okay, you are to stay away from all MARTA property if there's any active suspension against you. Once you are released, you need to verify whether there's any active suspensions against you. If there are, you cannot return to MARTA until that suspension ends. Do you understand, sir?
Yes, ma'am.
Thank you.
Thank you, Judge.
You okay?
Yeah.
Careful. Next, we have position 12, Edwards.
Mr. Howard, what's the announcement for this case?
That case will need to be handled by a conflict attorney. We represent, right, we have a conflict in that case.
Oh, all right. Ms. McLeod, are you counsel for Mr. Juan Pierre Edwards?
I am, Your Honor. Good morning.
Good morning, good morning. All right, Mr. Edwards, your case is 22 CR 001580J. And this is regarding a battery and obstruction of an officer charges from March 18th, 2022. Now, Mr. Edwards has two other matters. 21 CR 004522J and 20 CR 005525J.
Yes, Your Honor.
Go ahead. With regards to all three cases, what's the defense's announcement?
Your Honor, we want to take a plea on this. I've spoken with my client. I was just getting an offer from the prosecutor on this, Your Honor.
Okay. Have you had an opportunity to, have you already received one and have you discussed?
I have, Your Honor, but I haven't been able to discuss it in detail with my client.
I see.
Because I
Okay,
just found out about the other cases that he has. We would like, of course, for all of them to run concurrently and to be resolved today.
okay. Ms. Sari, are you the prosecutor in this matter?
Yes, Your Honor.
With regards to all three cases, is the offer a concurrent sentence?
It is.
All right, so it appears to be a concurrent sentence, recommendation, excuse me. So Ms. McLeod, you will still need to speak to your client.
I would, Your Honor.
Okay, so the phone number at the jail is 404-612-2392. And you
I
would
do
have
have to speak with him again, Your Honor, now that I have the offer.
You will need to speak to him, yes?
Yes, Your Honor.
Okay, so he's been removed from the seat to go await your phone call.
Thank you, Your Honor.
All right, thank you. All right, so we're going to put position 12 on hold. And who do we have in the seat?
Going back to position 29, Mr. Rosado.
Okay. Mr. McLean, you've had an opportunity to speak to your client.
We have, and fully understanding the procedures and advantages and disadvantages, Mr. Rosati would like to enter a unnegotiated plea of guilty.
They're gonna call. Oh, wow.
Could you give me that position number again, please?
I think it's 25.
25, thank you.
Is that correct?
Yes, it's 25.
Okay. This is Jason Jamal Rosati, is that correct?
Yes.
All right. Case number 22 CR 001563F. And this is going to be a negotiated plea. Is that correct, Mr. McLean?
An unnegotiated plea.
Oh, a non-negotiated, okay.
Right.
Okay. All right, Mr. Rosati, you have been advised of your right to remain silent. Your attorney is Mr. McLean. We are going to engage in a non-negotiated plea hearing, which means that the prosecutor is going to give me one recommendation and your attorney is going to give me an alternative recommendation. Before you make a decision as to whether you want to plead willingly and voluntarily to this case, I will let you know which option I will select. So for purposes of just the plea hearing, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Okay, Mr. Segura, could you please let me know what's the state's recommendation?
The state is recommending 12 months to serve 90 days, credit for time served 15 days, balance probated, FVEP, ADET, a stay away from the 216 St. Andrews Court, a Johns Creek location, and no further contact with Michaela Ojette, spelled Micaela, Lajot, Lrajotte, and her son, Jay Ojette.
All right, go ahead, sir.
Our recommendations are mostly based on the facts of this case, as well as because we see that he has a simple battery offense in 2011, and we're just concerned that due to the relationship between the victim, Ms. Ojette, and the defendant, we have more concerns about her safety.
All right, is this his spouse or are they significant partners?
We see that as significant partners and have been together for these 3 years.
All right. Mr. McLean?
Your Honor, the reason he would like to ask the court to consider his alternative recommendation, which would be time served with any other conditions the court feels is appropriate, is that he says he's got a Cherokee hold. So he is he's coming from a rather practical standpoint. He is saying, I've got to go see Cherokee County on my hold. He anticipates that Cherokee County will be a long and drawn out process, which is in the future, and that's his best guess. And for efficiency's sake in his situation, he's accepting responsibility by entering the plea, but would like to ask for time served so he can get on to the other county. I've noticed that he does have employment. When I looked in Odyssey, it was March of 2022, which is literally this month, and it's an auto concern.
All right. I'm trying to look up his nature of that hold. Okay. This is not an isolated incident with regards to Ms. Michaela Rajotte. Mr. Rosati has other matters which have gotten him involved with the law with regards to a November 30th, 2020 incident on a bench warrant, with regards to a September 9th, 2019, with regards to a simple battery matter from September 9th, 2019, with regards to a DUI matter from April 28th, 2021. And then, of course, with this particular case in which he was booked in on March 17th, 2022. This is a series of infractions with the law. As I said, this is not an isolated matter. So I'm accepting the state's recommendation that it will be 12 months to serve 90 days, given credit for 15 days. So he would have to serve how many days? Is that 30 more days at the Fulton County Jail?
Correct. 30 more days in the Fulton County Jail. It would be that style of extra days.
Do I have the math correct, Mr. Segura?
Let's see. If I believe so, 90 days, 15.
With good behavior, the 90 becomes 45, and subtract the 15, that leaves the 30.
I don't want to misspeak. I mean, if it's 30 days, then that's how much time. If he decides to plead guilty, he would have 30 more days at the jail, according to according to what I calculate and according to what Mr. McLean.
That's accurate as well.
Okay, so we all on the same page. He would have 30 more days to serve at the jail. And then after that, Cherokee will be able to pick him up to address whatever matters are holding him in Cherokee County. And once that's resolved, then he will report to probation to begin his probation in Fulton County for this case. So if we can unmute courtroom 2. Mr. Rosati, did you understand what I just stated?
I did.
And do you still want to proceed with the plea?
No,
Okay,
I want to take it to trial.
okay. So, Mr. McLean, I understand that your client is going to enter a plea of not guilty. Is that your understanding?
That's fine, Your Honor, yes.
Okay, all right. And Mr. McLean, do you waive a reading of the accusation?
We do. I've shown him the accusation and visiting him, and will ask the court for the 10 days.
All right, thank you. Mr. Rosati, Jason Jamal Rosati, this is 22 CR 001563F. You have been accused of battery, domestic violence, and cruelty in the 3rd degree from a March 12, 2022 incident. These are misdemeanor offenses. Pursuant to the waiver of the accusation, we will proceed to further information. As misdemeanor offenses, and upon your entry of a not guilty plea, the case will be scheduled for a trial before a division judge in state court of Fulton County. At the time of the trial, the state, the prosecutor, would have the complete burden to prove the charges against you beyond a reasonable doubt. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. And those those sentences could be served separately, that is consecutively or they could be served together concurrently. Given this information, how do you plead?
Not guilty.
All right, sir. Your case has been arraigned and it's further notice for trial. And presently you have a $10,000 surety bond for these cases and the Cherokee County hold. If you make bond, then Cherokee will come down and pick you up so that you can, because once you make bond, you'll be released to their hold. Do you understand, sir?
Yes.
All right. Anything else, Mr. McLean?
Nothing, Your Honor. Thank you.
Thank you.
Position 21, Mr. Pettis.
We have, and I'm going to apologize, is Isaiah Dumont Pettis.
Yes, ma'am.
Okay, Mr. Pettis, your case number is 22 CR 001-584E. You've been accused of battery domestic violence from a March 18th, 2022 incident. You've been advised of your right to remain silent, and your attorney is Mr. Mike McLean. Mr. McLean?
Your Honor, he would like to put this on the jury trial calendar. He would like to ask the court to consider a signature bond. The state made him an offer which reflects their assessment of the case and would have involved a few extra days of jail had he taken the plea. But this is actually a co-defendants, a mutual disturbance between two people. The other person is on our calendar today, and looking at the overall situation, Mr. Pettis would like to try the case.
All right. So based on what I'm looking at, the recommended plea appears that he may have to serve an additional 15 days or 16 days and then be placed on probation to complete domestic violence intervention program and have no violent contact with James Long. Is that the plea offer, Mr. Segura?
Yeah, it is.
All right. And I don't know, is our cross defendant on this calendar?
Yes, Your Honor. Yes, Your Honor. Actually, I had calculated 9.5 more days.
Oh, 9 days?
9.5, right.
Okay. We round those off to 10 days. All right. And let me see. And it looks with regards to Mr. James Long, that he would be, he won't be required to complete any additional time, but he would be on probation and domestic violence program. I don't see why both of them can't be released within 24 hours if they decide to take the plea. So if you want to engage in a non-negotiated plea, I'm willing to consider it as long as his record is not too significant.
I think he has an insignificant record. I discussed with him all types of the pleas, but what he would like to do is ask the court for a signature bond so he can prepare for the trial. He intends to move in with a friend. I realized the recommendation was no further violent contact, and he appreciates that, but at the same time, there won't be any more problems, and he's going to move in with another friend, so there will be less friction, and things will be worked on and made satisfactory.
All right. The last bond order was issued by Judge, might be me, I don't know, let me see, by Judge Mincy on March 19th, 2022, which is about 2 weeks ago. And no further violent contact, 2,500. All right. So before I arraign the case, let me consider the bond. I'm trusting Ms. Harrison. Good morning.
Good morning, Judge.
All right. I'm looking at position 21.
Yes, he has 3 cycles, 2 out of Kentucky. First arrest here in Georgia. His last arrest was December of 2019 for tampering with physical evidence. No disposition listed on that arrest.
Okay.
Prior to that, he had a 2019 given false name to officers, and that was a diversion. Nothing further.
All right. And does it indicate when he moved to Georgia?
It does not.
And I have a Kentucky address for Mr. Pettis.
Right. It couldn't have been long ago because he's quite young. I think he's something like 21 years old, give or take a year.
20.
Are you 20? Okay.
That still doesn't give him the ties. Youth doesn't necessarily tie him to the state.
No, he's planning to move in with, he's lost his apartment. He does own a car. Let's see, your job, Mr. Pettis, is where?
I got hired at Ivy Hall Assistant Living, a CNA job.
The CNA stands for Certified Nursing Assistant. So he's going to be working in an assisted living facility as a certified nursing assistant. It's kind of like
McLean, the bond's going to be 1,500. That's the lowest I can go. It's going to be a surety bond. I don't have the sufficient predicate ties with the community. And I don't even need to listen to hear the prosecutor. I mean, that's the lowest I'm going to go.
Very good, Your Honor. And he does have a plan B. An organization is going to try to help him make that bond tomorrow in that case.
We're going to arraign his case then? Do you want to file a waiver of arraignment? Shall I?
We can waive the formal reading and just put him on the trial calendar and ask for the 10 days, yes.
Mr. Isaiah Pettis, you are accused of battery domestic violence from March 18, 2022. And with regard to this case, with regards to this case, this is a misdemeanor offense. Upon your entry of a not guilty plea, the case will be scheduled for a trial before a judge or a jury. With regards to this case, when the case goes to trial, the prosecution would have the complete burden to prove the charge against you beyond a reasonable doubt and to overcome your legal presumption of innocence. If the state prevails, you could be looking at a penalty, and you are convicted of said offense, you could be looking at a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
All right. I accept your not guilty plea. Your case is arraigned and further notice for trial. Your bond is going to be modified to $1,500 surety bond. You are to have no contact with James Long. Do you understand?
Yes, ma'am.
You are to stay 200 yards away from him. You're not to communicate with him in any way, form, or manner. You're not to return to any property anywhere he lives. So I'm assuming, I don't know where the incident, I think it was on the bond order. Let me see.
Actually, Your Honor, they had planned to be in a situation, I think the state had planned for it as well, if I'm not mistaken, to be in a situation of no further violent contact while they went to, for example, counseling or something like that. And
Mr. McLean, I have no idea what the cross defendant intends to do. And in an abundance of caution and the fact that Mr. Pettis has insufficient ties with the community, I want him to stay away from the alleged victim and cross defendant until this case goes to trial.
Understood.
So unless Mr. Pettis has a problem with it, I'm being a new resident to Georgia, if you violate the no contact order, you could be arrested and charged with a felony matter of aggravated stalking, which could result in no bond for up to 3 months. Do you understand, Mr. Pettis?
Yes, ma'am.
All right. So I'm sorry I'm putting all your plans awry, but once you make bond, no contact with James Long, you cannot return to the property in which you cohabitated with him. If you have personal belongings there, you can return one time only with a police officer to retrieve your personal belongings. That visit cannot exceed 2 hours long. You are not to be in possession of any illegal drugs. You cannot consume illegal drugs, and no weapons and no firearms. Within 30 days of being released on bond, you must update the court with your current mailing address in, I'm assuming, somewhere in the metro Atlanta area
Yes, ma'am.
within 30 days, which means you have to come down to the clerk's office at 160 Prior Street and give us your new address in person, as well as your email and phone number.
Yes, ma'am.
Understood?
Yes, ma'am.
All right. So this case has been arraigned and further notice for trial. And Mr. McLean, you will send the proposed bond modified order to Ms. Grace, all right?
Yes, Your Honor.
Thank you.
Thank you.
Going back to position 12, Edwards.
All right. Mr. Edwards has been advised of his right to remain silent. His attorney is Ms. McLeod, and I understand that y'all were conferring about a possible plea. Ms. McLeod, what's the announcement?
My client is going to take a plea, Your Honor.
All right, and would it be for all three cases right now listed?
It
on the
will be,
calendar?
Your Honor.
Okay.
It will resolve all of his open cases in the State Court of Fulton County.
All right, that sounds good. Let me see. He will be on probation, so would he be able to report to probation immediately, or would he have to defer that until other matters are resolved?
Your Honor, I was under the impression he was just going to do some more time.
Your Honor, he does have a hold or an open case.
In
Where?
this jurisdiction or in Superior Court or
It's in Superior Court, yes, Your Honor.
All right. Your client has an open felony case, Mr. McLeod. Does he still want to proceed?
I was not aware of his open felony
No
cases.
problem.
I thought he had open state court cases, Your Honor.
Well, yes, he does. He has 3.
Which was what I understood. I was unaware that he had an open felony case.
All right, let me see.
I have the case number.
Yes, please.
20 CP 193758.
All right, just give me a moment. I'll see if he's on a UJR or something.
Yes, that is an open case, but he's not being held on the felony, Your Honor.
All right, he has a bond?
I believe so. I just checked the jelly, and the only thing that's holding him in are his misdemeanor cases. So if he were to take a plea, once he finished the additional jail time on these 3 sentences, he will be released. But obviously that felony case would still be open, but he's not being held on that.
Okay. I see. So if
It
he
looks
takes the
like,
plea,
yes, it looks like Ms. McLeod, your client made bond on the 20 CP 193758 on September 23rd, 2020.
okay, so he will be able to leave jail. I just wanted to be clear on that after if he takes the plea here, once he does the time, he will be able to leave.
According to the jail screen, he does not have a hold because he's got a bond and he's been in jail. So unless the only possible remote situation would be unless they revoked his bond for these arrests.
I understand.
All right, because these all occurred subsequent to making bond.
That's my understanding. Okay.
Okay. Can we unmute courtroom 2, please? All right. Mr. Juan Pierre, Edwards in case 22 CR 001580J. Mr. Edwards, we are addressing the 3 open pending misdemeanor cases that you have in the Fulton County State Court. Do you understand, sir?
Yes, ma'am.
You have 1 open felony case with the Fulton County Superior Court. Are you aware of that?
Yes, ma'am.
All right. Now, presently, it appears that you made bond in that case with Second Chance Bonding Company. And I cannot tell right now whether there's been any revocation or any holds on that bond as a result of your subsequent arrest in the state court cases. Do you understand, sir?
Yes, ma'am.
So presently, we are operating under the knowledge that if you take this plea, that you would have to serve additional time and then you'll be released to be placed on probation.
Mr.
All right? But as I said, I cannot absolutely guarantee whether there are any holes in the Superior Court case. Do you understand, sir?
I understand.
So given this information, would you still like to proceed with the plea?
Yes, ma'am.
All right. We are addressing 22 CR 001-580J, in which Mr. Edwards has been accused of battery and obstruction of a law enforcement officer from March 18th, 2022. He also has another case, 21 CR 004-522J, in which he's been accused of battery, family violence, and criminal trespass, and 20 CR 005-525J, in which he's been accused of simple battery and simple assault. So with regards to all three cases, if this is going to be a plea hearing, Mr. Edwards, could you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. All right, Ms. Sauri, as the ASG, what is your recommendation going to be a concurrent recommendation for all three cases?
Yes, Your Honor.
Go ahead.
The recommendation is 12 months to serve 120 days, credit for time served 12 days, the balance probated, and FBIB, no contact with the victims, and I'll give their names shortly, a stay away from the incident location, and that's to run concurrent with the other two open cases. Your Honor, this case, the victim in this case is Joshua Edwards. It's the brother of the defendant. He previously had a simple battery in 2017 that was null-priced. The victim was Joshua Edwards, the same victim today. It was dismissed through diversion because the defendant signed up for anger management. Subsequent to that, there was another battery, family violence, simple assault family violence, where his mother and Joshua Edwards again was the victim. And Your Honor, the mother's name is Shanette.
Alicia Allen? No?
No, her name is Shanette, SHANNETTE. Last name Reed, REID.
Okay.
And the incident location is 5401 Old National Highway. So, Your Honor, we would just like for you to take into account that there is a reoccurring victim with this defendant. His name is Joshua Edwards, and it is the defendant's brother. Again, we did null-price 2 cases in the past regarding this defendant, and he sits before us today again with the same victim.
All right.
Nothing further.
Thank you. And 120 days with credit for 12 days, that would give him how many more? I have 54. Does he have to serve 54 more days at the jail?
My understanding was it was 47, Your Honor.
So I believe if he gets 2 for 1, he'll have to serve 60 days. If he served 12, I think that brings us down to 48. I think today may be his 13th day in custody.
It is.
So he would have 40. If my math is correct, I believe he would have 47 days to get to 60. And with 2 for 1, I think he will be released at that time with good behavior.
Do you agree, Ms. McLeod?
Yes, Your Honor.
All right, so he would have 48 more days to serve at the jail.
Including today.
Including today, yeah. Okay. Ms. McLeod, any response?
No, Your Honor.
All right, and do you stipulate to the factual basis, venue, and ID for all the 3 open state court cases identified?
Yes, Your Honor.
All right. Mr. Edwards, this is regards to all these 3 cases involving Joshua Edwards and Shanette Reed, and staying away from the entire apartment complex at 5401 Old National Highway, not just the unit where they stay, but the entire complex. Are you willingly, voluntarily, and knowingly want to enter this plea?
Yes, ma'am.
All right. Have you consumed any kind of medication or alcohol recently?
No, ma'am.
Have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with the representation of your attorney, Ms. McLeod?
Yes, ma'am.
If you decide to enter a plea with these 3 cases, it may have an adverse impact upon any of your other open cases, including the one identified in Superior Court of Fulton County. Are you still willing to move forward?
Yes, ma'am.
All right. And do you understand what no further contact means?
I do.
All right. That means you have to stay 200 yards away from Joshua and from Shanette Reed, that you cannot return to the entire apartment complex.
I understand.
Your Honor, I'm sorry to interrupt. If we can add Alicia Allen on the no further contact order as well. She was a victim in one of the cases.
All right, so I was wondering about that. Okay, so that means there are 3 victims from whom you have to stay away. That's Joshua, your brother, Shanette, your mom, and this young lady, Alicia Allen.
I don't know who that is, Your Honor. I never heard of that name before.
Well, it was a simple battery, simple assault. It may have been a stranger.
Last time I checked, man, it was the only 2 people involved. That was my brother and my mom, Miss Chanel. And now I correction, and one of the other incidents, I think it was the second case, it was my brother and his significant other and my mom.
And what's the name of the significant other?
Lyndon Arrington.
Not listed.
Exactly.
Juan Pierre, accused of simple battery, simple assault, criminal trespass. This was back in January 23rd, 2020, where you allegedly struck Alicia Allen by striking her in the face with your hand. And you were you were arrested on March 28th, 2020, and given a signature bond. So that's the other person. All right.
Yes,
Do you still want to move forward with the plea?
Yes, ma'am. I don't know who Alicia Allen is, but I would go ahead and move forward.
Well, it's a sad situation, but
Your Honor, it's a possibility that he may have known this person by a different name. But she is obviously not someone he has been around a lot, since he doesn't know who she is.
So, Your Honor, just to provide some clarity.
Yeah, Mr. Walker, I just want to make sure that Mr. Edwards understands the cases to which he's pleading. He understands the cases in which his mother and brother involved.
I do.
All right.
Correct. There was a case at a McDonald's between a random stranger, and perhaps that's why he's unfamiliar with her name, but I just pulled the report, and the stranger's name was Alicia Allen.
Okay.
I don't know if that does that. Well, I don't want to talk to him. I don't know if that rings a bell, but it was the incident at a McDonald's with the stranger.
Let's see if the penny has dropped. Mr. Edwards, does that ring a bell, so to speak?
It does. She poured hot coffee on me. It does.
And Your Honor, I have the address for that McDonald's as well.
Oh, I have it.
Okay.
5115 Old National Highway.
Yes, Your Honor.
Well, it sounds like it's close by to where the other location is, but this one's in.
They're both on Old
Yeah.
National. Yes.
Okay, all right. Okay, Mr. Edwards, that is the gist of your three cases. I hope you recollect the alleged facts of these three cases.
I do.
All right. So in addition to staying away from mom and brother and the apartment complex, you will also have to stay away from the McDonald's at 5115 Old National Highway, all in College Park. Would that be a problem?
No, ma'am.
All right, and you do understand that you need to serve 48 more days at the jail?
I understand.
All right. So if you decide to plead guilty to the charges in all these three cases, you would have to give up your constitutional right to go back to court, to have the assistance of counsel to assist you in challenging the state's evidence, present your defenses, confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
How do you plead to one
Yes.
count of battery and obstruction of a law enforcement officer in case, listen, in case 22 CR 001-580J? How do you plead?
Guilty.
How do you plead to battery, family violence, and criminal trespass in case 21 CR 004-522J?
Guilty.
How do you plead to simple battery and simple assault at the McDonald's location in case 20 CR 005525J? Repeat.
Guilty.
Your sentences will run concurrent for all the charges in all these three cases, and your sentence will be 12 months to serve 120 days, credit for time served 12 days. And so in effect, you would have to serve 48 days, including today. Once you have completed your time at the jail, you will report to probation, which is going to be located at 132 Mitchell Street. You will do so within 48 hours of being released. You will be placed on probation to complete a 6-month domestic violence intervention program. You will have no contact with Joshua Edwards, Shanette Reed, and Alicia Allen. You will stay away from the entire apartment complex at 5401 Old National Highway and the McDonald's store at 5115 Old National Highway, all in College Park. If your probation fees shall be waived, but you must complete all these programs during the time that you're on probation. You will report every month. And I think that's it. Anything else, Mr. Edwards?
No, ma'am. Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Your Honor.
Your Honor, that concludes my business for the day. May I be excused?
Do you not represent position, was it a James Long?
No,
That's
Your Honor.
position 19.
Position 19, that was,
Yeah, it was the co-defendant to Mr. Izzy or Mr. Pettis,
yes.
Deshaun Long.
Is Mr.
No.
Long in the courtroom?
Mr. Long?
Position
Sorry.
19.
Norris?
No, Your Honor, and I actually represented Mr. Pettis at his initial hearing, so I would not be able to represent Mr. Long anyway.
Oh. Mr. McLean represented Mr. Pettis.
Today, but at the initial hearing, I represented him, Your Honor.
All right, guys, we have a little bit of a confusion. Who do we have in courtroom 2 right now?
This is position 22, Mr. Pierce.
Okay, Ms. McLeod, we really need to clear up that issue, so please remain.
That's fine, Your Honor.
Okay.
But I actually represented Mr. Pettis when
Oh,
we
yeah,
were
yeah,
paired initially.
Yep, and that should have been noted to begin with before we address Mr. Pettis. Okay, position 22, I have Tremaine Darius Pierce charged with battery, substantial physical harm in case 22 CR 001-525B. Mr. Pierce has been advised of his right to remain silent, and his attorney is Mike McLean.
That's correct.
What's the announcement today?
If memory serves, I believe that's a negotiated plea.
All right. Mr. Pierce, for purposes of the plea, may I place you under oath? Do you solemnly, is your hand up? I can't tell. Okay. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. You may place your hand down. Mr. Segura, what's the recommendation?
The state is recommending 12 months to serve 45 days, credit for time served 16 days, balance probated, 12 weeks anger management, a stay away from Atlanta Towers located at 1270 West Peachtree Street, Northwest Atlanta, and no further contact with Marixa Thomas. Marixa spelled M-A-R-I-X-A. Thomas, common spelling.
Okay. Mr. McLean?
That's correct, Your Honor. We asked the court to accept the negotiated plea. He does understand that my calculation is 6.5 extra jail days, and the 12 weeks anger management is certainly something that will be kind of expensive. So we would ask the court to financially consider him for a break on probation monitoring fees for several months. Because the 12 weeks worth of class is going to be several $100s.
And 7 days. So I'm just rounding it off to 7 days.
Right.
Does he have any other holds that anyone knows about?
I don't think so.
All right. So after 7 days, he will have to report to probation. Does he have a current address, mailing address and phone number and email for probation?
I believe that I took the information down. If I can find my paperwork. Here it is.
If you want to put that in the chat to JCS, that would be helpful.
I filled out with him at the jail a brother's phone number, his phone number, a good address. We've got the probation information.
Okay, all right.
For the contacts.
Okay, good. All right.
Sure do.
Okay, and you stipulate to the factual basis, venue and ID, yes?
We do so stipulate, yes.
Okay, thank you. Mr. Pierce, you've already had discussions with your attorney. First of all, have you consumed any kind of medication or drugs recently?
No, ma'am.
And have you understood the proceedings so far?
Yes,
And are you satisfied with Mr. McLean?
yes.
Is anyone forcing you to take this plea today?
No, ma'am.
If you decide to plead guilty to this charge, you would have to give up your constitutional rights to go back to court and challenge the state's case in a court of law before a judge or a jury. Namely, you would have to give up your right to have the assistance of counsel to challenge the state's evidence, present your own defenses, examine your witnesses, confront your accuser, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And how do you plead to one count of battery causing substantial physical harm?
Guilty.
I'm sorry?
Guilty.
I accept your plea of guilt to this charge. Your sentence is 12 months to serve 45 days, credit for time served 16 days. You have 7 more days to serve at the Fulton County Jail. Once you've completed that time, you will report to probation within 48 hours of being released. Do you understand, sir?
Yes, ma'am.
And that would be at 132 Mitchell Street in Atlanta, Georgia. While you are on probation, you will complete 12 weeks of anger management classes at your expense. I will waive your probation fees for 6 months, for the 6 months that you are on release. So you have 6 months where you don't have to pay probation fees, but you need to complete the anger management classes. Do you understand? You are to stay away from the Atlanta Towers at 1270 West Peachtree Street in Northwest Atlanta. Do you have any reason to return to that location?
No,
And you are to have no contact with Marixa Thomas, M-A-R-I-X-A. You are to stay 200 yards away from this person and not communicate in any way, form, or manner. You understand?
yes.
All right. Do you have any questions about your sentence?
No.
No?
No.
All right, that concludes this case. Thank you. Next case, please.
This is position 29, Mr. Walton.
Thank you. We have Daryl Walton, case number 22 CR 0015858, accused of terroristic threats from August 12, 2021. All right, and we have Mr. Walton, Daryl Walton. You've been advised of your right to remain silent. Your attorney is Mr. Mike McLean. And Mr. McLean, what are we doing for your client today?
Your Honor, he has a felony matter, which the state is aware of, and he has a $3,000 bond, a good bond on this case at this time. He would like to appeal to the court for a possible signature bond or something like a $1,000 good bond, if that's not possible, because the felony case would really be in the driver's seat and in terms of his litigation in the upcoming months.
Okay. Let's see now, Ms. Harrison, may we have Mr. Walton's priors, if any?
You're on the 16 cycles. Last arrest was December of 2019, driving while license suspended. He pled a NOLO. He currently has an open case pending, 22 CP 207568. And a 2015 conviction for aggravated assault with deadly weapon, 4 counts, possession of firearm, and cruelty in the 3rd degree. He has a 2012 battery conviction, and it appears he have a failure to appear hold in Ohio.
Okay.
Nothing further.
Thank you. Mr. Segura, there is an argument for a signature bond for this case in light of his open felony case. Response?
We will not desire that. We will mostly desire a surety bond. I think as noted before, this is basically continuing with the related felony case. In this particular case, the defendant made terrorizing language towards the victim, Geraldine Harris, by yelling at her while she was in the bathroom that he will kill her and himself due to the relationship. And he mostly denied the signature bond because of the related felony case, which occurred 4 months prior. And in this case, it relates to the exact same victim and includes the same similar situations within April 26, 2021, in which the victim, the same one, Ms. Harris, told her when she got home, the defendant dragged the victim out of her vehicle by her hair, then accused her of cheating on him, and he struck her with his fist. And later on, she said that after she went back to her house and she was in the bathroom breastfeeding her son, A. Harris, who was just 2 at the time. And at the moment, the defendant barged into the bathroom and again began striking Ms. Harris with his fist. And in the time he was striking Ms. Harris, he also struck the 2-year-old child, which resulted in visible abrasions to the child as well as to Ms. Harris. So because how related these two incidents are with the same victims and very close within about 4 months, we will not be okay with a signature bond.
Right. And Mr. McLean?
Right, Your Honor, that is the case to which I referred. The state's aware of the related case, more or less. It is the felony case that would be the main thing he would be facing in the next several months. So that's why he'd like to ask the court to lower the bond on this one, so as to concentrate on the other.
Understood. That's not a legal reason. Request denied. Are we moving forward with arraignment?
Yes, Your Honor. He's going to go to trial on this.
All right. And would you like me to arraign the case? If so, do you waive reading of the accusation or?
We waive reading. I've shown him the accusation and we'd ask for 10 days to file motions.
All right, thank you. Mr. Daryl Walton, in this particular case, you're accused of terroristic threats, a misdemeanor offense from August 12th, 2021, involving apparently the same alleged victim as in case 22 CP 207568. With regards to the misdemeanor charge, you are presumed innocent in the eyes of the law until the case goes to trial, and upon your entry of a not guilty plea, the case will be so scheduled. At the trial, the state would have the complete burden to prove the charge against you beyond a reasonable doubt and to overcome your legal presumption of innocence. If the state prevails, you could be convicted and face a penalty of up to a year in prison, as well as a fine of up to $1,000. Given this information, how do you plead?
Plead not guilty.
All right.
Ask a question though.
I can answer any questions you've got if you'd like to go into a breakout or a phone call.
I just want to know if I have a bond for the.
Your current bond is $3,000. It is a surety bond that was established on March 19, 2022. In addition to the bond amount, you are to have no contact with Shadarian Harris. You are to stay 200 yards away from 4775 Santa Fe Trail in Atlanta, Georgia, and no drugs, no alcohol, no weapons.
So how much would I have to pay? And
Bonding company typically charges anywhere from 10 to 15% of the bond amount. And
all charges?
I'm sorry?
Your Honor, can I ask him these bond questions and procedures?
Yeah.
Could I ask him to inquire of me by phone if he'd like to? He could call my desk or my cell phone. I'll mute myself.
Certainly. All right.
Okay,
Mr.
and I just want to make clear that counsel is aware that he's being held on a no bond, so it's kind of a moot point.
Well, that's on his felony case.
Right, that's the felon.
All right. Anything else, Mr. Walton? We good?
So I'm still on no bond for the felony.
Yes, sir.
Okay.
All right. Thank you, sir. Next case, please.
Yeah, Mr. Long here. I don't have this number. I apologize.
No problem. James Long was the cross defendant, and this is Ms. McLeod and Mr. McLean.
I think Long would be number 19. Is that correct?
That's correct. Deshaun James Long.
Right. We represent Mr. Pettis.
Okay. So Mr. McLean.
And Ms. McLeod represented him once upon a time. So
I did.
Not that
So
far ago.
how does that work out now between PD and conflict?
We're going to have to get another conflict attorney.
Your Honor, I was not asked to represent Mr. Long today.
Well, understood.
Which I couldn't have done anyway.
Right. Correct. And Mr. McLean could not have represented Mr. Pettis because he was initially represented by conflict at initial appearance.
Well, I don't think there was any restriction on me representing Mr. Pettis. I could be wrong, but I was not aware of the representation by Ms. McLeod. We had no information. There would be no information flow regarding Mr. Pettis to us anyway. So I represented Mr. Pettis today. She happened to represent him in the past. Who represented Mr. Long in the past? No idea. But we just need to get another conflict attorney for Mr. Long now. And that leaves it clean.
Do you concur, Ms. McLeod?
I do, Your Honor.
All
because
right.
I did speak with Mr. Pettis extensively, and I represented him at his initial hearing.
Okay.
Right, Judge, and I think, yeah, we should not have represented him today. It sounds like he was a conflict for our office, which is why Ms. McLeod was brought on board. And I guess going forward, and Ms. McLeod sent a message in the chat. If you're appointed at first appearance, if you'll file an entry at that time or as soon as possible thereafter, then when it comes up on SAP, we know, because Mr. Kelball and others, we get, we see that they're their clients because they file it right after.
So this is what we're going to do. Mr. Pettis, which is position 21, has been arraigned and further notice for trial, and his bond has been modified to $1,500. And Ms. McLeod, as you represented him to begin with, do you have any objection to continuing representation?
Not at all, Your Honor.
Okay, so Mr. McLean, please CC Ms. McLeod on the order modifying his bond.
Okay, Your Honor, I'll point out I don't object to the conflict defender representing him in the future. That's fine.
Okay. No, I'm just trying to clean it. I'm just trying to clean it. Okay.
Right. There's nothing to correct though in terms of we're not going to represent Mr. Long in any case.
I'm not talking about Mr. Long. I'm talking about Mr. Pettis. You have a proposed order for modifying his bond, and that's going to be CC'd to Ms. McLeod. Right. And also indicate in there that from this point onwards, Attorney Maureen McLeod will be representing Isaiah Pettis.
Oh, we'd be happy to do that, sure.
Okay, and Ms. McLeod, if you can, do you have Mr. McLean's email address?
I don't, Your Honor.
All right, it's just like his name appears on the screen, Mike McLean, Mike.McLean at fultoncountyga.gov.
Thank you, Your Honor.
All right. Please send him your contact information so that he can include that in the proposed order and that Mr. Pettis is then aware of his continued representation with conflict.
Thank you.
All
and
right.
Ms. McLeod, if you could call my cell phone after court, which is 770-842-5471, I'll get your email and send to you the bail bond project literature, their plans, all that stuff that I have from there.
Okay, can you put it in the chat, the number in the chat?
Sure.
All right, thank you. All right, Ms. McLeod, with that squared away, you are now released. Thank you very much.
Thank you, Your Honor.
Okay.
Have a good day.
You too, thank you. All right. Moving on to Deshaun James Long. This is case number 22 CR 001581E. Mr. Long, if you could unmute courtroom 2, please.
He's in medical. He's up here in medical.
He's in courtroom 2, yes?
No, he's in medical.
Medical. Oh, medical's not on my screen, so let me move on. I see you. I see you. Yeah. I'm sorry. I'm working with 3 screens over here. So, all right. Excuse me. All right. Mr. Long, my name is Judge Law. First of all, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and that's where the rub is. At your initial appearance, it appears that you were represented by counsel the first time that you were in jail, the first time that you came before a judge. And I'm not certain if you remember the name of your attorney.
No.
You do not recall?
No, I don't remember. All I know is it started with an M.
Was it McLeod?
I don't remember who it was.
Was it male or female?
Male.
Male. Male beginning with an M. Mr. Howard? Would that be Mr. McLean?
I can, it could be. I can go through and find out if who represented him at first appearance. I just need to check something. I can go back.
All right.
I'll report back in a second.
So presently, Mr. Long, again, I repeat, not discuss the facts of the case. Anything you say, your statements can and will be. Anything you, I know they're very noisy. I know, sorry. Okay. Thank you, Deputy. All right, thank you. As I was saying, anything that you say about the facts of the case, those statements can and will be used against you. The Public Defender's Office would need to withdraw from representing you because of the nature of this case. There are 2 people involved, Mr. Pettis and you. And currently, Mr. Pettis has pled not guilty. He has been given a $1,500 surety bond, and he has been instructed to have no contact with you. As I understand it, I am going to have the prosecutor articulate the recommended sentence if you decide to plead guilty today. But please understand, you do not have to make a decision today until the conflict defense counsel speaks to you. Mr. Segura?
Now, initially, our pleading was 12 months to serve 26 days, credit for time served 13 days, balance probated, FWEP, and no further violent contact with the victim, Azarias Pettis.
All right. What that means, Mr. Long, is that if you decide to plead guilty or no contest to this charge, your sentence would be, your time at the jail would be completed and you'll be released within 24 hours if you don't have any other holds. You would be placed on probation. You would need to complete a 6-month domestic violence program and have no further violent contact with Isaias Pettis. And that's only if you decide that you want to willingly, knowingly, and with full understanding, plead guilty or no contest to this charge. Have you spoken to an attorney with regards to this possible plea offer?
No.
All right. As I don't have any conflict counsel on Zoom today, I will have to reset your case to Tuesday, unless you want to choose to represent yourself. That's entirely up to you.
I can represent myself.
All right. Mr. Howard or Mr. McLean, do you have the paperwork for Mr. Long?
Mr. McLean, do you have, I imagine he may have it, Judge.
I did, knowing that I was representing Mr. Pettis,
Oh.
I did not print out the package for Mr. Long.
All right. Mr. Long, have you spoken to any attorneys in the last 48 hours?
No.
Oh, well, Your Honor, actually, come to think of it, I do recall what each citation and each affidavit for arrest says. They are somewhat at variance because I did look that up with regard to Mr. Pettis's case. So naturally, I looked at both affidavits and both citations to see what each person was accused of. The police officer made a mistake in writing up the affidavits because they basically substituted each defendant's name and had the identical victim, which would have been impossible. The citations were different from the affidavit.
Mr. McLean, this is all academic at this point because you do not represent him.
Right.
So I can
print out a package that came from the source of the package that were prepared and send them to wherever the court would like.
Excuse me, Judge, this is Katrina. I looked up the counter for that day. A PD off.
It was Mr. McLean. I already verified it was Mr. McLean.
It was, yeah, it was, they had Finley on there, but yeah, it was.
I've totally forgotten having done that, and I do apologize.
That's okay. Mr.
Right.
McLean, I'm going to put you in a breakout with Mr. Long.
Well, Judge, it doesn't change the issue. Is that
doesn't change the issue, but
right. So I'm saying
I need someone to talk to this young man.
He needs a conflict attorney because we've talked to his co-defendant at length.
I know.
And we can send the paperwork to him, Judge, but
Yeah.
the only way to cure this is to have a conflict attorney appointed for him.
I totally agree. Mr. McLean?
Yes.
All right. We're going to put you in a breakout with medical. Miss Lewis, if you can place that out, please.
I can.
All right. Courtroom 2, who do we have? Anyone from positions 1 to 15?
We have position, we have an add-on, position 1 for SAP, Desmond Davis, and also Stanford Smith, position 28. There are only 2 left.
All right. Mr. Howard, do you represent either one of those?
What were the position numbers again, Judge?
Desmond Davis, the add-on on and position 28, which would be Mr. McLean.
Right, both of those are Mr. McLean's case.
All right.
Put me in the breakout with Mr.
Long?
Long.
Okay, go ahead. Ms. Lewis, please place Mr. Howard in that breakout room and then tell Mr. McLean to come back to the main room. Thank you, Mr. Howard.
Thank you.
Francois, was that Desmond Davis seated right now? Desmond Davis?
This is Desmond Davis.
Okay. Mr. Davis, your case is 22 CR 001-648J. You've been accused of possession of marijuana less than 1 ounce from December 14, 2021. And your attorney is going to be Mr. Mike McLean. Please do not, please exercise your right to remain silent until, well, at all times. Anything you say, your statements can and will be used against you. And your attorney, Mr. Mike McLean, is present. Mr. McLean, we have ascertained who represented Mr. Long. It was not you. So let's move forward to your next case. Desmond Davis, add-on position number 1.
You got me curious now, but I will move on to the next one.
All right.
Desmond Davis was a person who only has, for today's hearing, 1 count of simple possession of misdemeanor amount of marijuana. And he was offered time served. And we had the accusation, but all the accusation really tells you is the date. Our packet did not give us any other information. And I said to him, you know, we're in a situation where the next SAP is only 2 days away. And given what we're doing in terms of jail interviewing and going to court, it is unlikely that I will, unless the state sends me something, it is unlikely that I'll get an investigator to go find out more or have time to get on Odyssey and find more information about this single thing. We suspect it may have stemmed from a case that maybe two counts were dropped. So we don't know if he's got.
Mr. McLean, I sent you the report. Do you not have it?
Okay, was that this morning?
That's what you requested at the beginning of the calendar, correct?
Exactly. Let me check
Well, I
my
sent
email.
it, and I checked his other felony cases. It doesn't appear that this is a part of those felony cases. They
Very
all
good.
have 3 different incident dates.
Okay, I'm going to check what he sent me, Your Honor, and
Go ahead and check. Mr. Walker, meanwhile, what is the state's position on this case
On
that
Mr.
is unrelated to the felony cases?
It was time served.
Right.
Time served,
He's
Your Honor.
been in custody for, okay.
37, 38 days around. I'm not sure the exact date because it's been rescinded, but 37 or 38 days.
And Mr. McLean, does your client want to take that plea or?
well, as soon as I show him this information, here it is, Desmond Davis report. I'm going to open this up and go into breakout with him, I suppose, and read it to him, and perhaps that will jog his memory as to the scene. Because all we had was the date.
Okay.
Now we've got more.
All right, Mr. McLean, put a pin on that report and we're moving on to position 28. Mr. Davis, please have a seat in the gallery and we will return to your case. Thank you. Position 28, we have Stanford Smith, 22 CR 001-416E. Stanford Smith is accused of willful obstruction of an officer and obtaining unlawful entry into MARTA from February 17, 2022. Mr. Smith, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have the right to an attorney, and representing you is Mr. Mike McLean. Mr. McLean, with regards to Stanford Smith, what would your client like to do?
Negotiated plea, Your Honor.
Okay. Mr. Smith, please raise your right hand. If we could unmute courtroom 2. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Walker is Mr. Segura, is this a time served with balance suspended and stay away from the Water Civic Center location?
It is.
All right. And Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do so stipulate, yes.
All right. Mr. Smith, have you consumed any drugs or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with the representation of your attorney?
Absolutely. Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
If you decide to plead guilty to these charges, you would have to waive and give up your rights to go back to court to have a trial before a judge or a jury, have an attorney assist you to challenge the state's case, confront your accuser, examine witnesses, present your defenses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
How do you plead to unlawful entry into molestation and willful obstruction of an officer?
Guilty.
Your sentence is 12 months to serve 36 days, credit for time served 18 days. This is a time served plea. The balance is suspended. You are to stay away from the MARTA station at Civic Center, which is identified as N2 on the map. And if you return to that location, you will be arrested again. Please check with MARTA if you have any active suspensions against you and if they will permit you to return to Civic Center. Understood?
Yes, ma'am.
All right, thank you. You're free to go.
Thank you, ma'am.
All right. Francois, do we have any more positions in courtroom 2?
As far as Mr. Desmond Davis, is he done?
No, he will be talking to Mr. McLean. Mr. McLean will be calling courtroom 2 at 22392. And at South Annex, who do we have?
Position 31, Ms. Weaver, and I believe that's Mr. Howard's client.
No, that's mine, Tabitha Weaver.
Okay.
All right, let's do Ms. Weaver. Do you have any other cases, Deputy Milton?
No, this is the only one I have, Your Honor.
All right, okay. This is Tabitha K. Weaver, case number 19 CR 005173F, accused of battery from June 18, 2019. Ms. Weaver, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Mike McLean. This is going to be a plea, Mr. McLean?
Yes, Your Honor, negotiated plea.
All right. So, Ms. Weaver, I'm going to hear from the prosecutor first, and then I will hear from your attorney, after which I'll ask you some questions to make sure that your decision to enter a plea is being done knowingly, voluntarily, and willingly. Mr. Segura, what's the recommendation?
The state is recommending 12 months to serve 162 days, credit for time served 81 days, balance probated, 8 weeks anger management, 40 hours community service, and stay away from 1196 Arlington Avenue, Southwest Atlanta, and no further contact with Anthony Thomas. Thank you.
Thank you. Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do so stipulate.
Okay. Ms. Weaver, have you consumed any kind of drugs or medication or alcoholic beverages?
No.
Have you been able to understand the proceedings so far?
Yes, ma'am.
And are you satisfied with the representation you received from Mr. McLean?
Yes, ma'am.
Good. All right. Now, if you decide to take this plea today, you would have to give up your legal and constitutional rights to go back to court, to have a trial before a judge or a jury, to be able to challenge the state's evidence and present your own defenses, confront your accuser, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
How do you plead to 1 count of battery?
Guilty.
Your sentence is 12 months to serve 162 days, credit for time served 81 days. If you have no other cases holding you at the Fulton County Jail, you will be released within 24 hours. You will, do you have a current mailing address and phone number?
Yes, ma'am.
All right. So probation will send you a notice to appear before probation, and they will send that to your mailing address. If you don't hear from them within the next 5 or 10 days, please report to probation at 132 Mitchell Street. Do you understand?
Yes, ma'am.
Okay. While you're on probation, you will complete an 8-week anger management program, complete 40 hours of community service, and you are not to return to 1196 Arlington Avenue in Atlanta, Georgia. You're also to have no contact with Anthony Thomas. You're not to communicate with him through any kind of way, form, or manner, including in person. I will waive your probation fees. Please make sure to report to probation, complete the conditions of your probation, and if you complete all the conditions of your probation will terminate.
Okay,
Understood?
ma'am.
Okay.
Yes, ma'am.
Any questions, Mr. McLean?
None, Your Honor, thank you.
Thank you. All right.
Your Honor?
Yes, Ms. Milton?
Okay, is that 132 Mitchell Street, Atlanta, Georgia?
Yeah, that's for probation too. She needs to report.
Okay, and is there a telephone number for that?
JCS probation, they will put that in the chat to you.
Okay, and how many days she's supposed to be reporting? I mean, is it what day?
Normally, she's supposed to report within 48 hours, but since she's got a good mailing address, probation will send her notice to her address. If she doesn't hear from them in 10 days, she needs to report to them in person.
Okay, thank you.
All right, thank you.
Bye.
Bye. Have a good one. Okay. All right, Mr. McLean, please call courtroom 2 with regards to that case on the add-on calendar, 22392. Yeah. And Mr. Howard, what has been your discussion with Mr. Long?
Judge, I spoke with Mr. Long about, I guess, what was being offered, the options. Obviously, I didn't get into the details of its case. I strongly advised him to have this reset to Tuesday so that an attorney can get into all the facts and circumstances, defenses, and all that with him. However, he has indicated that he wishes to resolve the matter today, understanding everything involved. So he would, go ahead and, I believe, resolve the case pro se today. I explained to him that, we wouldn't be able to represent him, and he didn't want to wait to be represented on Tuesday. And he says he understands everything and wants to resolve it.
Mr. Long, if you decide to choose to represent yourself, you would be responsible for understanding how the criminal law and criminal procedures apply to the facts of your case. You would need to understand that I cannot give you legal advice and how it impacts upon your residency, your occupation, or any professional licenses or your ability to own a firearm or so forth. All these issues, you would be responsible. If this is a charge of battery, domestic violence, if you plead guilty to that charge, it will remain on your record. Any subsequent arrests for another battery, domestic violence charge could automatically be a felony charge. So, given this information, would you like to wait till Tuesday to speak to an attorney to explore your options? And then I will also consider I will also reconsider your bond, or would you like to proceed with a plea?
Like to proceed with the plea.
I'm sorry?
I would like to proceed with the plea.
All right. Mr. Howard, do we have the paperwork drafted for him to review?
No, Judge, I don't have any plea paperwork for him. We didn't prepare plea paperwork for him.
All right. Mr. Long, Mr. Walker, you need to email the plea paperwork to medical so that he can review it, including his waiver of assistance of counsel, so that he can consider that. Let me see, before we move on to that part of the case, Ms. Harrison, what are Mr. Long's priors? Please unmute.
Your Honor, he has 6 cycles. Last arrest was February of this year for failure to appear. I'm showing 1 misdemeanor conviction in 2022 for driving while license suspended or revoked. Nothing further.
All right. Okay. I'm willing to reduce his bond to $1,500 surety bond. No further contact with Isaiah Pettis. And he may return to the location where he lives. And if he wants to consider that, or if he wants to move forward with the plea. Mr. Long, what would you like to do?
I would like to move forward with the plea.
Okay,
Hey, hold on. Will I still be getting out today?
I'll reduce your bond to 1,500, and if you post your bond with $1,500 with a surety
My
company.
thing, I don't have family out here. I don't have no way of paying a bond because they say I'm a high risk. And I did not miss court. I got my court date changed, but my court date was 3 days in advance. And I had a ride, but they canceled on me. So I had no other option but to get the court date changed. And the lady said, even though I'm getting my court date changed, I still might get a warrant issued on me. And when I found out I had a warrant, I turned myself in and I did my time served. I never missed court. It was just my ride canceled on me 3 days in advance, and I had no other way of getting up there. So I got my court date changed, but she told me since I had court in the next 3 days, they was probably still gonna issue a warrant out on me. And once I found out, I turned myself in and did my time served.
Understood, sir. But you've got a prior conviction and you've got a failure to appear, and your bond has been reduced to 1,500. So if you post a bond through a surety company, they charge between 10 to 15% of the bond.
I tried to go through a bonding company with my friend.
Okay,
I don't have they're not gonna let him do it because he's not my family member.
okay. Then the next question is, do you want to proceed with the plea, or would you like to reset the case to Tuesday so that you can speak to an attorney? A conflict attorney will be speaking to you, exploring your options, and seeing if you want to take a plea and end up with a conviction on your record, or whether you want to consider other options.
I guess I'm gonna have to wait till Tuesday because I won't be out today.
The bond will be modified to $1,500. I will do the bond order. And this case is reset to April 5th, SAP calendar. And Ms. Lewis, can we be sure that conflict counsel is appointed to speak to him anytime before that? Thank you.
Thank you, Judge.
All right, we'll just go over the calendars then. I don't think I have anything else. We have Mr. McLean who's still talking to
We still have Mr. Desmond Davis.
Yeah. So are they done?
They're still on the phone. Are you done?
He just called. He talking now.
All right. Francois, I'm just going to go over the calendar, and once I'm done, Mr. McLean should be done.
Okay.
Thank you.
You're welcome.
On the probation revocation calendar for Boyne Rosborough and Tate, both cases were administratively closed. For the add-on calendar, Desmond Davis is on, well, we're waiting to see the outcome of that discussion. All right, on the main SAP calendar, position 1 was a plea. Position 2, Andrews Amanda.
Yes, Judge, I've submitted a written waiver of presence and arraignment, so that just needs to be reset jail jury.
All right, this is going to be a waiver of arraignment and further notice for trial. Position 3 was null pros. Position 4, Carlicia Bradner.
She was released, Your Honor.
Okay, thank you. Position 5, 6, and 7 were pleas for Mr. Braggs. Position 8, Shanika Collins.
Judge, we're asking that be reset to next Thursday. We're gonna have a social worker follow up with her.
All right, so this is reset to April 7 SAP.
Yes.
For an evaluation. Okay. Yes. Position 9, Gary Cooper.
He was released, Your Honor.
All right. Position 10 was a plea, 11 was a plea, 12 was a plea, 13 was arraigned and further notice for trial. Position Andrew Freeman was released on March 28th. Further notice for trial. That's Khadija Freeman was, I guess, same person. No, different person. Released on March 26th. Further notice for trial. Position 16 has filed a waiver of arraignment and further notice for trial. 17, Paul Heist.
Judge, I believe Ms. McLean filed a waiver of arraignment and presence for him, Judge. Not guilty.
All right, so further notice for trial.
Yes.
Position 18 was a plea. Position 19, Deshaun Long, is reset to April 5th. I'll do the bond order, reducing it to 1,500, same conditions as position 21. Position 20, Ashley Matthews, response?
Judge, we're asking that that be reset to our competency calendar on next Thursday. We're going to submit it an order in connection with that case.
All right. Reset to our competency calendar for April 7th, SAP. 21, it has been arraigned and further notice for trial, bond modified, represented by conflict, Ms. McLeod. Position 22 and 23 were pleas. Position 24, Rashante Ross was released, further notice for trial. Position 25 was a arraignment and further notice for trial. Same for position 26, further notice for trial. He's got a court date before Judge Morrison on August 3rd, Mr. Seals. 27, Christopher Smith. Mr. Howard?
Let's see, Judge, what was the announcement on him?
He was released.
Okay. He's
Thank
released.
you.
Excuse me, Judge.
Yes, sir.
I'm sorry to interrupt. Whenever you're ready,
Yeah.
the Davis Desmond is ready.
Yep. Position 28, Stanford Smith was a plea. 29 is arraigned and further notice. 31 and 32 were pleas. And position 30, Sterling Ware. Mr. McLean?
Sterling Ware is going to trial, Your Honor. He's aware of the charges. He's seen the accusation, and he'd just like to put that down on trial.
Have you filed a waiver of arraignment?
We have not. I don't know if he's been arraigned before. He has a serious case in Superior Court that he has no bond on, and that's not going to change for the time being. So
He's never
bond is
arraigned.
moot.
I'm sorry, Ms. Lewis, has he been arraigned?
No, he was not.
Okay, Mr. McLean, please file a waiver of arraignment and direct that to Ms. Grace today.
And we'll ask for 10 days on motions on that, Your Honor.
All right, but go ahead and file the waiver of arraignment today.
Okay.
Thank you. All right, moving back to Mr. Desmond Davis. What's the announcement, Mr. McLean?
Your Honor, he is more concerned about other holds that he has and wishes to address those today. I tried to explain to him that we can't address things that aren't on our calendar. I don't think there's any progress that currently he would like to make on this particular case in front of us.
All right, Mr. Davis, good afternoon, good morning. My name is Judge Law. Your other cases are in the Fulton County Superior Court as a felony matter. That is,
They actually misdemeanors. They pre-trial holds. That's what holding me in jail. My bond's already paid on that case. I got a job and I work. I've been doing good. I ain't been in no trouble. Pre-trial is holding me on these cases. My family have been trying to get in touch with
let
them.
me see what are those cases and then I can see if I have jurisdiction over them.
That's all I'm asking. Somebody address it because pre-trial is not getting back to my family about it. The bonding company is waiting on these people.
Okay, you need to stop talking
Yes, ma'am.
because you don't understand what you're saying. Unless you have case numbers to give me, you need to keep quiet.
No. No.
She's the one that called me.
My goodness, young man. Okay.
I'll just send it to everybody.
Listen very carefully before you start rattling off and end up incriminating yourself. Do you understand?
I understand. I got a long record, Judge.
22 CR 001648J is a Fulton County state case. It's a misdemeanor offense of possession of marijuana less than 1 ounce, filed on March 22nd, 2022 for an incident date of December 14th, 2021. Your other case is 22 CP 206835. That is a Fulton County Superior Court case. The charges rising from an incident of February 21st, 2022. Charges: felony sale of MDMA, felony possession of cocaine, misdemeanor failure to obey a traffic control device, misdemeanor possession of marijuana less than 1 ounce from a February 21st, 2022 incident. These are the two cases that I see. Oh, here's another one. 21 CP 201749. This is a case filed in Fulton County Superior Court. Charge: public drunkenness, misdemeanor from July 28, 2021. Misdemeanor obstruction of an officer from July 28, 2021. Misdemeanor possession of marijuana less than 1 ounce. That's a misdemeanor. Possession of Schedule 2 controlled substance, felony. Possession of methamphetamine, felony. You have 2 open cases in Fulton County Superior Court, which have a mixed bag of felony and misdemeanor charges. And you have 1 open active case in Fulton County State Court, which is what we're dealing with right now. And it has only 1 misdemeanor charge of possession of marijuana. Right now, I can only deal with the Fulton County State Court case because this is state court. If you want to argue about the Superior Court cases, that would have to be scheduled before a Superior Court judge. All right. Now, again, Mr. McLean, what would we like to do with this single count of misdemeanor offense in this only 1 misdemeanor state court case?
Well, he does understand the offer, Your Honor. So since it is 1 count of simple possession, I would like to just point out the severity of the offense is what it is. The date of the offense is relevant, and would like to ask the court for a signature bond on it.
All right. Who is the prosecutor?
I am, Your Honor.
All right, Ms. Sari.
Yes, Your Honor. I won't hold the court too long, but given the 2 open felony cases that were similar charges to this marijuana charge for this case, he did have a marijuana possession charge back in 2009, marijuana possession back in 2010, 2015, 2016. Your Honor, given his history and nothing has changed regarding this case, we will ask that the court keep the bond as set.
All right. Bond is modified to $5,000 signature bond through the jail. No drugs, no alcohol, no weapons, and no firearms. And Mr. McLean, do you want to arraign this case?
We could, Your Honor. I'll waive formal reading of the charges. Like I said, we always did have the accusation itself, and we read it.
All right. Mr. Desmond Davis, you've been accused of a misdemeanor offense of possession of marijuana less than 1 ounce. You do have a right to a trial on this charge, and upon your entry of a not guilty plea, the case will be scheduled for trial, upon which the state has the complete burden to prove the charge against you beyond a reasonable doubt. If they prevail, you could be sentenced and face a penalty under our current jurisdiction for up to a year in prison and or up to $1,000 fine. How do you plead?
Guilty.
Okay, we could do that today as well.
All right.
It's
I
fine.
thought he understood the law, but apparently not. So, Mr.
Okay. So
Davis, you've been given a $1,000 signature bond through the jail on this charge. How do you plead?
Guilty.
All right. Your sentence, all right. If you are pleading guilty, Mr. McLean, are we going to proceed with a plea hearing right now?
We can do that. That'd be fine. I can sign, if he gives me express permission, I can sign the blank forms for him if he would like me to do that.
All right.
And Your Honor, would you like me to put the recommendation on the record?
This is time
Yes.
served.
Yes, and would it be time served?
Yes, Your Honor, that's
All
correct.
right. Mr. Desmond Davis, do you give your attorney, Mr. Michael McLean, express permission to sign on the plea documents on your behalf?
No.
All right. So, Mr. McLean, if you could call the jail, please, and go
Okay.
over the documentation with him. Because clearly he has no understanding of what's going on. Francois, I'd have to beg your indulgence. We still need to accommodate Mr. Davis a little longer. Sorry.
Yes, Judge?
We just need him to talk to Mr. McLean a little longer because he doesn't understand what's going on.
All righty.
All right. Please mute your screen. Thank you. All right, folks, we have to be in recess until Mr. Davis comes back. Oh, anyone who's not involved with this case, you're free to go. I guess it'll just be Ms. Sowry and Mr. McLean, myself and probation and Ms. Grace and, well, it won't be probation. Probation, you're free to go. Anyone else is, Mr. Segura is free to go, Mr. Walker, Mr. Howard.
We have the competency calendar, Your
Yeah,
Honor.
Judge, we can.
Oh, we do? Okay, sorry
Yes,
about
ma'am.
that. All right.
So we can break out and talk about those. That it's just announcements pretty much on most of them.
All right, okay. Okay, Miss Lewis, if you can put me, Mr. Walker, Mr. Derek Howard, and Miss Asha Amin Williams into a breakout room, please.
Yes, ma'am.
And Mr. Howard, please text or email Mr. McLean that we'll get back to him as soon as possible. Thank you.
Okay, all right.
We're back.
Judge, I was just letting.
I guess if y'all want to go ahead and Katrina, if you want to bring her back to handle that, then that.
Okay, I'll go in there and let her know.
Yes. And then you can put me in there with them.
Already in there, you just got to select. That's
I
all.
just need to hit select on. Okay.
All right, Mr. McLean, what's the announcement of Mr. Davis?
Now that he has a clear let's see, it just told me recording in progress. Okay, I don't have to click anything. Now that he has a clear understanding of the conversations we've just been having, I pointed out to him how the sequence went. He says, oh, I would like to have that signature bond. I'll just try the case later.
All right, to resume. Mr. Davis, as I was saying, you do have a right to a trial, and at that trial, the state has the complete burden to prove the charge against you beyond a reasonable doubt. If you choose to enter a plea of not guilty, your case will be scheduled for trial, and if the state prevails in carrying its burden, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
Your case is arraigned and further notice for trial. And please be advised that any information you need on the Superior Court matters, you would have to reach out to the public defender assigned to those cases. Understood?
Yes.
All right, thank you. All right, that concludes our SAP calendar. Ms. Lewis, could you please beam me back into the
You
other?
should be able to go back in there, Judge. Just have to accept it. It should be down there for you. You see it?
No, it's not coming up there.
It's not.
Judge, may I be excused?
Yes, thank you.
Thank you, Judge. Have a great day.
Thank you.
Yeah.
Yes, Francois?
Yeah, we're completed here in courtroom 2 as well.
Yes, everyone's excused, Ms. McLeod, everyone. I'm just. gonna-
Thank you, Your Honor. I just came back in because I got a phone number from my client and someone had been asking about that earlier.
Okay, all right. Thank
So I
you.
just came in to post that information
All right.
because I think probation needed it. But I wasn't sure how to contact probation.
Ms. Grace, Ms. Lewis?
Yes, Judge, I'm here.
Okay, is Ms. Grace there too?
I probably got to kick her out the room.
Okay,
Let me see. Did she come back on?
that's okay. I can let her know what I'm going to do for the competency calendar. I'm just going to go over that with you right now.
Oh, no, I don't even have a copy of the calendar out. Right, hold on 1 second.
One of the cases needs to go back on our regular SAP calendar.
Okay, hold on 1 second. I think Melissa can hear. Melissa, can you hear me in the courtroom? Yeah, I don't. No, Melissa, I think Melissa signed out altogether.
Okay.
Yeah. Yeah, she selected the wrong thing. Yeah, she probably left the meeting. Okay, well, I can go and get that information. Hold on
Okay.
1 second, Judge.
No, I mean, I'll talk to her also, but position 1 is reset April 28th, position 2 in 28th.
April the 28th.
Yeah,
These are all back on the competency calendar.
right. All of these are back on the CC. Position 2 and 3, May 5th. Position 4, April 21. Position 5, April 14. Position 6, April 21. Position 7 and 8, April 14th. Position 9 is April 7th, SAP calendar, not competency.
April 7, SAP.
Yeah. And we need a Vietnamese interpreter.
Vietnamese interpreter. Okay.
Position 10, April 14th. Position 11, April 7th. 12, April 28th.
April the 28th, number 12. Okay.
And position 13, April 7th, competency.
April 7.
Only one case goes back to SAP.
Yeah, and that's one I have to have an interpreter.
Yeah.
Okay. All righty. I got it.
Okay.
Okie dokie.
All right. Okay, I'll see you later.
Okay.
Okay, thank you. Yeah.